Generally, the Fourth Amendment is considered our protections against unreasonable searches and seizures. The word unreasonable is important. The definition for a reasonable search generally today is this. It must be accompanied by a warrant. It must be supported again by probable cause. They should have probable, I don't know where I was, and then I typed this, have probable cause set forth in an affidavit. It has to be authorized by a neutral or detached magistrate, and it applies whenever there is a reasonable expectation of property, or excuse me, of privacy. So if I'm growing marijuana on my front yard, I probably don't have a reasonable expectation of privacy. If somebody driving back can go, wow, Lisa's growing the wacky tobacco, you know, that the police could come onto my property and say, hey, what's going on here? But if I've got it in my basement, then I have a reasonable expectation of privacy, and then my protections are in place. There are some exceptions in what are called urgent circumstances. If they're making a lawful arrest and evidence is uncovered as a result of that lawful arrest, if a police officer is in hot pursuit of a fleeing felon, if he's chasing me because somebody saw me come out of the bank with my dial over my hands, and I drop the bag half a block down, and he's following me, he can pick that up and say, hey, I saw her drop that. He doesn't have to have a search warrant to pick that up off of the sidewalk when he's pursuing me. If it is a bona fide emergency, now this is
yeah, how's that?
Hurricane Katrina. Something like that. Yes, a bona fide emergency, but are we going to set aside our constitutional privileges at that point? These are some things that are a little shaky. Lesser invasions of privacy, such as a stop and frisk. If they stop me, they pat me down, and they go, whoa, what's this? Then many courts are allowing that to be used as evidence. Under the Fourth Amendment is known as the exclusionary rule. And essentially what the exclusionary rule says is this. Any evidence that is uncovered in violation of the Fourth Amendment cannot be used in court. Now, some courts argue there will be time to time protection of our personal and our property rights. This establishes a grand jury system. The grand jury was designed to be a buffer between the citizen and the power of the state. The grand jury is designed to keep an individual from going through the expense, the trauma, the jeopardy of a trial, unless other common citizens are convinced that there is probable cause to make the individual undergo a trial. As a fact-finding body, the grand jury acts as a check on government. If the prosecutor takes in evidence and the grand jury is unconvinced of how solid it is, its believability, its credibility, they can refuse to indict. Now, military cases are exempted from the grand jury system, but it is important to understand that the Fifth Amendment expressly recognizes the possibility of the use of capital punishment, because it says no one will be deprived of life without due process. So in their thinking, that capital punishment was certainly feasible as long as it was properly executed. In the Fifth Amendment, we are protected against what is called double jeopardy. That means you cannot be tried twice for the same offense in the same jurisdiction. And then it was designed to protect you against government harassment. Because this went on in England all the time. If the king didn't like someone, Parliament didn't like someone, they could keep him tied up in litigation. You know, they'd be found not guilty. The next day they'd be back in court tried again. So double jeopardy protects us from that. It also helps to protect us because it tells that we cannot be coerced into incriminating ourselves. We cannot be forced to testify against ourselves. Their reasoning, again, was someone might confess just to stop torture. They might confess to protect another person. There would be any number of reasons people give false confessions. And then it was stated that individuals should not, because of their human dignity, they should not be forced or coerced into cooperating in their own self-destruction. That should not be allowed to happen. This compulsory self-incrimination has a very interesting history. We call it today our Miranda rights. And what had happened was a guy by the name of Miranda in Arizona was picked up on the charges of kidnapping and rape. After 2 hours of police questioning, he confessed. They went into court, and based on his confession, he was convicted. His attorney said, "Wait a minute, let me see that confession." And the confession had a statement on it, "I have given this of my own free will, I have not been convicted." And the attorney asked Miranda, "What does that mean?" And he was not able to explain to the attorney what that meant. And so the attorney got the idea that if you don't, and I think this is a critical thing for us to understand, if you don't understand your rights, it is as if you do not have them. And it was based upon that argument that the Miranda versus the state of Arizona went all the way to the Supreme Court, and the Supreme Court agreed that an individual must know what their rights are, have the presence of an attorney to explain that to them in order to be convicted. Now, it's interesting. Miranda was retried. His confession was thrown out. This is just free. This is just interesting. He was retried. They got evidence, they got witnesses, they got all that, and he was convicted again. After he served a number of years, he was paroled, but he had a hard time finding work. But he was an enterprising guy. And at this point, this was when the Miranda rights were first coming out. Now, all of us have seen enough cop shows that we can say it. I have the right to remain silent. If you, choose not to, you have the right to an attorney. We can say all that, but the police at that point couldn't even say it. So they carried little cards. And when they arrested people, they would read it. Wow. Miranda supported himself until he was killed in a bar fight, going around signing police officers' Miranda cards for a slight fee. That's the history of Miranda versus the state of Arizona, but it was definitively helping explain what the Fifth Amendment was all about. The other thing in the Fifth Amendment it says is the government cannot take your property for public use without just compensation. Now, what has not happened is a clear legal definition of taking. We might think taking means you took my house and now there's a Walmart sitting there. On the other hand, there are people who have tried to make the argument, hey, I own this building, and the government came along and declared it a National Historic Site, and now I can't paint it pink like I really wanted to. So they've taken it from me. There's no real legal definition yet of what taking involves. So again, if I hear one, I'll keep you posted. We'll have John Gale put it up on the announcement. We got to move quick. The Sixth Amendment is the right of criminal defendants to a speedy trial. Now, the term speedy depends on the circumstances. Generally, we are hearing that the state suits against Obamacare are on the fast track. They're going to be heard within about 2 years. Now, in all fairness, though, think about it. I have to tell you, this is again my opinion. I would rather live in a system that took 2 years to gather evidence to convict me than to live under Sharia law, where they can drag me in and the judge says you're guilty, and that afternoon they hang me. So this term speedy is a protection that I don't want to give up if it means 2, 3, 4 years down the road. It must be public. It must be tried in the state and the district in which the alleged crime occurred. You must be informed of your charges with sufficient time to prepare your defense. You have the right to confront and to cross-examine your accusers. You have the right to subpoena witnesses to testify on your behalf for your defense. And you have the right to counsel to the point that if you are not able to afford it, the state will provide it for you. The Seventh Amendment outlines what our rights are in civil cases. This dollar amount has not changed since the time of the amendment. Any civil act or any action involving $20 or more, you can demand a jury trial. If you think you can win $20, that's the benchmark. Now, it does say, interestingly, that the judge cannot substitute his opinion in the place of the jury's opinion unless he decides that no reasonable juror should have reached that conclusion. Now, I don't know, I can't give you any cases where this has ever been used. It may be out there, but I think the O.J. trial might have been a good one to try that one on. Again, for those watching by tape, that's my opinion. All right. The Eighth Amendment is our protection against criminal punishment. No excessive bail. And the reason behind this is this. Even though you have been charged with a crime, you are supposed to be innocent until proven guilty. You should not be required, if you are innocent, to place an unreasonable bail. The reason for bail is to make certain that you do not pose a danger to the public, that you're not likely to flee, to make certain that you're going to appear in court, and it should be no more than is necessary to ensure you appear in court based on the nature of your offense, your record, and your ties to the community. Now, on one hand, you could look at that and say, we need to give this guy bail because he showed up, he's been tried 70 times, but 70 times he showed up for court. So he's a good risk. We won't put any bail. Somebody on the other hand could say, I don't know, he might take off. Oftentimes, people with more money are more likely to have higher bail because they think they may have an easier way to flee than a person with less resources. Also, you'll see happening now, and again, especially in high-level cases, that individuals will be asked to surrender their passports, so it'll be harder for them to get out of the country. Then it specifically says no cruel and unusual punishment. This is unreasonable torture. This is disemboweling. This is mutilation. These are all kinds of things that were standard practice in English courts. Now, the Supreme Court has generally, they haven't ruled, but they've generally begun to follow what is called this argument, the evolving standard of decency. And what this argument says is that society has evolved to the point that capital punishment of any form is now considered cruel and unusual. We saw earlier in the Constitution that the provision was made for it if it was properly handled. But we're having an entirely different view kind of superimposed upon the Constitution at this time. The Ninth Amendment is called the unspecified right, and what it says, this was answered Alexander Hamilton's concern, this was put in for Mr. Hamilton, that essentially it says just because it's not listed here should not be construed that it's not the right of the people. So it's that simple. It says, the key word there is retain. It protects our rights.